Last week, a Clayton County judge issued a new ruling in the Hannah Payne case. For the first time in this entire appeal, a judge has actually explained in detail why she's not going to get a new trial. I'm Andrew Baxter, known online as Drew Breezy. I'm a retired police lieutenant with 29 years in law enforcement. I've covered the Hannah Payne case on this channel since the trial. This isn't a recap. It's a plain English breakdown of what this new order actually says and what it means for what happens next. I'm not an attorney. This isn't legal advice. My co-host John is an active 911 dispatcher, and normally we break these cases down together. This one's a solo video because it's a legal document and not a 911 call. I'm going to answer 3 questions. Once you understand these answers, you'll understand exactly what changed this week. Question 1, what did the judge actually rule? Question 2, does his reasoning hold up? And question 3, what happens now? So let's start. Hannah Payne was convicted in December 2023 of malice murder, felony murder, aggravated assault, false imprisonment, and firearm possession. The case involves the death of Kenneth back in May of 2019. Herring had just caused a hit-and-run crash. Hannah witnessed it, called 911, and followed his vehicle. What happened when she caught up to him is what's contested. Witnesses gave different accounts at trial. Payne was sentenced to life with parole eligibility, plus an additional 13 years. Hannah's defense argues her trial lawyer made a mistake, that he never asked the jury to be instructed on 2 legal defenses, citizen's arrest and the defense of others. That's called ineffective assistance of counsel. The claim that a lawyer's errors were serious enough to cost somebody a fair trial is what's known as ineffective assistance of counsel. And that claim is what this week's order actually decides. Here's the important part. This wasn't a retrial. The judge didn't decide whether Hannah is guilty or not, and he didn't resolve what happened in that struggle. What he did was very narrow, whether her trial lawyer messed up badly enough on those 2 jury instructions to justify starting the whole thing over. One more thing worth knowing before we get into the order. 2 words matter a lot here: chase and follow. Here's the sequence. While Hannah is still behind Herring's truck, the dispatcher tells her, quote, "We do not want you to chase him," end quote. That's the word chase. Hannah believes she wasn't chasing. She was following him, staying back, waiting for police. She even said it. The word follow doesn't come from the dispatcher until after the shooting. Only after the gun goes off does the dispatcher say, "You were not supposed to follow him." Now, that instruction, the one using the word the prosecution built its case on, was never given to Payne while any of this was happening. It came after. And I'll say this plainly, what actually happened once Hannah caught up to Herring is contested. Hannah testified that Herring grabbed her gun and it discharged as he twisted it away from her. Other witnesses described it differently. I'm not resolving that dispute here because the order doesn't resolve it either. It didn't need to. What the order decided was a bit narrower. So what did the judge actually rule? Well, the answer is he denied everything. Every argument the defense raised was rejected. The order opens with something the defense had mostly dropped, whether there was enough evidence to convict at all. And Judge Mack reviewed the trial record himself, acting as what Georgia law calls the 13th juror. That's actually a real legal standard. The judge independently has to weigh that evidence the way like a juror would, like, you know, he is the actual 13th juror. And he found in his analysis that the verdict actually held up. The real fight was over the 2 jury instructions. Now, on citizen's arrest, the judge actually confirmed something in the defense's favor. Georgia's citizen's arrest law at the time of the incident let a private person arrest somebody for a crime committed in their presence, and that crime didn't have to be a felony. A misdemeanor counted as well. But confirming the law is one thing. Applying it to what Hannah did is another, and that's where the order turns kind of against her. The judge points to Hannah's own testimony. She said she was following Herring to get his license plate number, not to arrest him. Once she had that number, her stated reason for following him was done, according to the judge. Everything after that, blocking his car in, the confrontation, that wasn't in the judge's reading an arrest in progress. So that's question 1. The judge confirmed the one legal point in Payne's favor, but ruled against her anyway based on her own testimony. Now, does his reasoning hold up? Well, this is the most important part of the video because it's exactly the kind of ruling that gets picked apart in appeal. Here's a simple way to think about it. Picture fixing something mechanical, and the manual tells you the textbook procedure, but what actually gets it running is sometimes a judgment call, something way different from what the manual says based on what's actually in front of you. So when a decision gets reviewed on appeal, it's the same split. Is the challenge about whether the judge followed the rule as written or about whether his read of the facts was right? Now, those get checked completely differently. A legal call gets checked from scratch. There's no benefit of the doubt. A factual call actually gets a little bit more attention because the judge was the one who actually heard the testimony. Judge Mack's order does both. On the legal question, is a misdemeanor enough for a citizen's arrest? He obviously got that right. It's now settled law. But on whether Hannah was making an arrest, that's a factual finding, and it's based on his read of her testimony. And appeals courts are supposed to leave factual findings alone unless they're clearly wrong. And that's exactly what an appeal will argue, probably. The second instruction, the defense of others, gets a different kind of denial. Hannah argued that Herring, still fleeing, was a danger to other drivers, and she was allowed to use force to stop that danger. The judge's answer to that, though, is once she'd already blocked Herring's car in, that danger was over, and you can't justify force against a threat that's already neutralized. This ruling is cleaner than the citizen's arrest one because it's built on the order of events, not what was in Hannah's head at the time. Perhaps what's not in the trial transcripts in Hannah's testimony rests in the 911 call transcripts. And I think my personal opinion is that's important because what she says when she walks up to the car makes a huge difference. She's asking him to get out. So is she still continuing this defense of others by preventing him from driving because he could simply drive around? Or is this, as the judge states, very clean and clear? There's two arguments and two different kinds of denial. One resting on a factual read of testimony, one resting on a timeline, and that difference will shape probably how this gets appealed. So what happens now? Well, this order can be appealed back up to the Georgia Supreme Court because here's the history. The first trip to the Supreme Court back in March never got decided on the merits. The state's proposed order, which was signed by a previous judge and turned out to contain a bunch of fabricated case citations, I know you all remember. The appeal got sidetracked sorting all of that out. Now, the Supreme Court sent it back with one instruction. We want a clean order without the fake citations, and don't let either side's lawyers write it for you. That's what this judge did. So this new order is that redo. If this case goes back up, which I assume it will, the justices are going to be reviewing Judge Mack's actual reasoning, not a citation scandal. I'm not going to tell you how I think this will go. I don't know. A denial at the trial court level doesn't mean the appeal is over. That's just how the process works. It also doesn't mean the outcome changes once it goes back up. Neither fact tells you what's going to happen. So first, the court. Judge Mack did what the Supreme Court told him to do. He wrote a clean order. He addressed both arguments directly. This gives the Supreme Court something it didn't have in March. It's an actual record to review. Second, the state. Now the prosecutors have a cleaner record without the citation problem, but they're defending a factual finding about a defendant's testimony, which is a different kind of fight than defending a clean legal rule. And then third, the defense. Payne's trial lawyer filed that original motion and lost it back in 2023. Then her appeals attorney argued that the trial lawyer's performance wasn't good enough. The appeals lawyer isn't defending his own work here. He's just arguing about somebody else's. The order denies the motion on every ground, but it does confirm one thing for the record. Georgia's citizen's arrest law applies to misdemeanors, not just felonies. What that means for any future appeal isn't something I can speculate about because I don't know. Here's the through line though. This case has been shaped twice by how carefully or carelessly legal documents get built. The The first order got thrown out because of what was in it. This one is the response to that failure. I hope walking through the actual order instead of somebody else's summary was worth your time. Watch for what the Georgia Supreme Court does with this order next, and when that happens, I'll be here to break it down. That's where this case stands. Subscribe if you haven't already, and I'll see you on the next one.